So we're going to continue with the next three panelists. Before that, I would like to remind you that for those of you following online, you can ask your question via the Q&A function of the Zoom. And for those of you attending in Brussels, do not hesitate to raise your hand at the end of the three next presentation. So Frédéric, I'll let you introduce the next panelist.
From Switzerland before the break, we crossed the border to Austria with Teresa Mörth. She is among us here in Brussels. Thank you for having come to Brussels. Teresa Mörth received the degree of Doctor of Laws from the KarlFranzens-Universität of Graz this year. So congratulations, Dr. Mörth. She defended the thesis International Law in Times of Emergency, the challenge of regulating emergencies in general international law and human rights treaties. Recently, she also published the paper COVID-19 as a threat to the life of the nation in international human rights law, diverging state practice. So we have somebody who worked a lot on today's topic. Thank you in advance for your presentation. The title of your work is the following one: Derogation from Human Rights Treaties in Times of Pandemic, with a question, de jure or de facto. You have also 20 minutes.
Thank you. Thank you very much. And thank you very much for the invitation and the unique possibility to come to this beautiful city and also present my arguments at this symposium. As it was already mentioned, the topic of my presentation is derogation from human rights treaties in times of pandemic, de jure or de facto. And despite the fact that we are already experiencing the second year of this pandemic, my presentation will focus on the initial period lasting from approximately January to May 2020, simply because I think that when it comes to derogation, it is, because of COVID-19, it is very important to take a look back at the beginning of this crisis and state practice at this time. The majority of states introduced extraordinary measures as a reaction to the outbreak of SARS-CoV-2, COVID-19, and many also declared states of emergency. Among those states, some notified of a derogation from the European Convention on Human Rights, the American Convention on Human Rights, or the International Covenant on Civil and Political Rights. And I summarize state practice by as I call it, three strategies of how states reacted to the pandemic. The first is the declaration of a state of emergency, the introduction of emergency powers, and the derogation from human rights obligations. The second is the declaration of an emergency and the introduction of emergency measures, however, without the official derogation from human rights obligations. And the last strategy is no emergency declaration, but again, the introduction of extraordinary measures to fight the spread of this virus. Now, considering the different responses to the same kind of threat, I analyze state practice amidst the pandemic, and I argue in favor of derogation because of COVID-19. I will focus on the meaning of derogation from human rights treaties, and also I will give a very short overview of the conditions set by derogation clauses. I will also draw on the distinction between the jure and de facto states of emergency, and of course I will examine whether COVID-19 constitutes a threat to the life of the nation as required by the three main human rights treaties. In their study on emergency powers, the two authors, John Farragon and Pascal Pasquino, observe that the Latin word derogare actually means partial abrogation or repeal of the law. At the same time, they translate derogation as a deviation from normal behavior and ultimately equate derogation with partial deviation and suspension. Considering the Latin meaning of derogation and also the definite character of abrogation, the equation of derogation and suspension as a temporary means is, in my opinion, inconsistent. On the other hand, the text of the derogation clauses confirms the synonymous use of derogation and suspension. Both Article 4 of the ICCPR and Article 15 of the European Convention refer to the right of derogation. In contrast, Article 27 of the American Convention refers to both suspension and derogation. The Inter-American Court of Human Rights also emphasizes the inherence of human rights to man, and therefore, according to the court, states cannot suspend such rights in an absolute sense, but only their full and effective exercise. The existing ambiguities suggest a focus on the concept of derogation clauses, and derogation clauses as contained in human rights treaties intend to temporarily free states from their human rights obligations to the extent necessary to cope with the ongoing emergency. Similar to the statement of the Inter-American Court, Article 15 of the European Convention requires states to inform the Secretary General when the provisions of the Convention are again being fully executed. And Article 27 of the American Convention requires information of the provisions, the application of which the state party has suspended. So one can say that when governments avail themselves of their right of derogation, certain rights remain unapplied to the extent necessary to overcome the crisis. And in my opinion, the definition of derogation that fits this concept of derogation clauses best is that of a temporary exception, which leaves the right enshrined in the treaty applicable per se, but leads to its temporary and partial non-application. So the key words, in my opinion, are really temporary and partial non-application. When governments avail themselves of the right of derogation, they must fulfill several conditions as set by derogation clauses. And of course, the most important condition is that states must experience an exceptional situation, either a public emergency, a public danger, or other emergencies threatening the life of the nation or the independence or security of the state. In the context of the pandemic, the meaning of an emergency threatening the life of the nation or the independence or security of the state is particularly relevant, and it can be summarized as an actual or imminent threat to the physical integrity of the state's population, the territorial integrity of the state, or the functioning of its organs. Another very important condition is that the condition of strict necessity, as measures derogating from human rights obligations are only permitted to the extent strictly required by the exigencies, which means that states are only permitted to derogate from human rights obligations in case ordinary measures are insufficient. This basically means that the mere experience of an emergency does not automatically allow states to derogate from human rights obligations, but that the limitation of human rights must be insufficient. Also, the condition of strict necessity implies the condition of proportionality, which means that, of course, every emergency measure must be proportional to the crisis faced by the state. Further conditions are the condition of the official proclamation of a national emergency, the notification to the international community informing about the derogation, the reasons for derogation, and so on, compliance with other international obligations, also the prohibition of discrimination, and of course the respect of non-derogable rights such as the right to live or the prohibition of torture, which must be respected at all times. And whenever states face this exceptional situation and also comply with derogation clauses, we usually speak of a de jure emergency. However, states do not always inform about emergencies and also apply emergency powers de facto. And in a classic de facto state of emergency, as it was defined by the ILA, states face an emergency situation, but governments opt against the formal invocation of emergency powers. Now, this can have two reasons. On the one hand, governments can continue with the application of ordinary means, but on the other hand, governments can also decide to impose emergency powers without the formal proclamation and of a state of emergency. I think it is very important to consider the second type of emergency in the context of the pandemic. And in order to do so, it is important to analyze whether COVID-19 constitutes a threat to the life of the nation according to human rights treaties, as only if the virus fulfills the conditions set by derogation clauses, states may also derogate from their human rights obligations. The question that I asked myself was, did some governments actually manage to continue the application of ordinary law despite an emergency, or simply imposed emergency measures without an official proclamation and an official derogation from human rights treaties? I think that there is no doubt that COVID-19 constituted and still constitutes a threat to the physical integrity of the state's population. It is a virus that transmits very easily from one person to the other, and the gravity of symptoms is unpredictable. Some people remain asymptomatic, but others suffer severely from this virus and even die. Also, COVID-19 constitutes a threat to the institutions of the state, because it is a virus that affects the work of parliaments, of courts, and also members of governments got infected. While it is true that one cannot really say that this virus is a threat to the territorial integrity of the states, at least in the beginning of this pandemic, we experienced some tensions because of the limited access to medical equipment. And therefore, in my opinion, COVID-19 constituted an actual threat already around the globe already from January to March 2020, and it constituted an imminent threat in to those states which had not yet reported infections officially. Even though facing this global threat to the life of the nation, only one group of states classified this virus as being so severe as to not only justify the declaration of an emergency, but also the suspension of human rights obligations. As I have already said, the condition of strict necessity under the derogation clauses requires states to stick to limitations and ordinary means as long as possible, even when they are facing a state of emergency. Therefore, one might argue that groups 2 and 3 complied with the condition of strict necessity and merely limited human rights, while the first group introduced 2 drastic measures requiring derogation. However, as I want to point out, there is another significant point to consider. Despite the differences in declarations, the majority of states introduced measures strongly resembling each other, or basically the same measures. The total number of derogations notified of by states during the first wave of this pandemic is 47, and some states provided detailed information about the emergency measures in their notifications. States such as Latvia, Georgia, Estonia, or Chile informed about the imposition of strict lockdowns, including severe movement restrictions, the prohibition of public events or gatherings, the closure of museums, theaters, cinemas, gyms, and so on. I think we all know the measures. Similarly, states such as Italy, France, or Spain, all states which declared states of emergency without derogating from human rights, introduced nationwide lockdowns, leading to the prohibition of leaving home except for exceptional cases or the ban of public meetings. And the same is true for states not declaring a state of emergency, such as Austria, the United Kingdom, or Turkey. In my opinion, the measures adopted by states conflict with the official strategies of how states dealt with COVID-19. Because of its character as a threat to the life of the nation, COVID-19 theoretically allows states to declare an emergency and derogate from human rights obligations to the extent strictly required by the exigencies. Many states opted against derogation. However, even when they did not declare a state of emergency or derogate from human rights treaties, they equally imposed lockdowns and severe human rights restrictions. This, of course, leads to the question whether derogation due to COVID-19 was necessary or the mere limitation of human rights is sufficient. I defined derogation as the temporary and partial non-application of human rights. And limitations, on the other hand, define the scope of human rights or allow restricting rights for reasons of national security, public order, or also public health. And with regards to COVID-19, the possibility of states to limit human rights for reasons of public health is, of course, particularly relevant. In its general comment number 29, the Human Rights Committee emphasizes that derogation from covenant obligations in emergency situations is clearly distinct from restrictions or limitations which are allowed even in normal times. Now, the committee did not clarify which differences between derogation and limitation it had in mind when adopting the general comment. However, I think that contrasting the meaning of the words limitation and partial non-application and focusing on the impact of the measures adopted also makes it possible to assess state practice during the pandemic. It is true that some states introduced more extreme measures than other states, or enforced them in a way that can hardly be qualified as strictly required by the exigencies. However, extreme emergency measures or their excessive enforcement by some states should not necessarily lead to the conclusion that other states merely limited human rights. Instead, it is important to distinguish between excessive emergency powers and their abuse, derogations from human rights obligations according to derogation clauses, and limitations. When governments decided to put their states under lockdown, the restrictions imposed were quite significant. Taking the example of the right to movement, people were not allowed to leave their homes except for the satisfaction of basic needs, such as buying food or healthcare. And assuming that such severe restrictions constitute a limitation of human rights makes it difficult to imagine restrictions of the right to movement qualifying of a derogation to the extent strictly required by the emergency. The complete prohibition of leaving someone's house or apartment, as it was the case in some states, would rather amount to a violation of the right to movement not even covered by derogation clauses. So, to summarize my arguments, COVID-19 fulfills the conditions of a threat to the life of the nation, and during the initial period of the pandemic, states around the globe at least experienced a de facto state of emergency. Even though several states did not declare an emergency or derogate from human rights obligations, they imposed measures strongly reminiscent of those which were officially declared as being derogatory. Human rights treaties permit states to limit human rights for reasons of public health, and states may derogate from human rights treaties only if ordinary measures are insufficient. However, the severity of the measures imposed strongly suggests that many states derogated de facto and ignored their obligations under derogation clauses. Limitation clauses apply to both times of normality and times of emergency, and therefore measures covered by such clauses must be less severe in terms of restricting human rights. If states impose measures requiring derogation, they should derogate officially to avoid de facto derogations, Or put differently, the transparent use of emergency powers is crucial to avoid derogations cloaked in limitations. Thank you very much for the attention.
Thank you, Teresa Mörth, for this very clear presentation of your research. When I started to work on the legal aspects of the pandemic in March 2020, the question of the application of the Article 15 of the Convention was one of the first that came into my mind. You brought many answers with your contribution, but I still have a few questions that we could discuss before lunchtime. Nous allons maintenant passer à une autre intervention qui sera la seconde en français de ce panel. Nous allons aller vers un collègue italien qui est manifestement francophile. C'est le professeur Pablo Passaglia. Il va nous proposer une contribution qui concerne la justice constitutionnelle en temps de pandémie. Vous allez voir qu'il va nous emmener des sources de la réflexion sur la justice constitutionnelle avec des auteurs comme Rousseau et Montesquieu, jusqu'à une réflexion appliquée à la situation actuelle, au rôle des cours constitutionnels pendant la pandémie. Le professeur Passaglia est professeur de droit comparé à l'Université de Pise. Il est docteur en droit de cette université, mais aussi de l'Université d'Aix-Marseille depuis 2001. Il est coordinateur pour le droit comparé du service des études de la Cour constitutionnelle de la République italienne. Il est aussi membre de l'Académie internationale de droit comparé et membre de la direction de l'Association italienne de droit comparé. Il est l'auteur de nombreuses contributions, de nombreux ouvrages, et parmi d'autres champs de spécialité, il y a la justice constitutionnelle qui va être en connexion avec le sujet qu'il nous propose aujourd'hui. Chers collègues, à vous la parole pour 20 minutes et merci d'avance.
Chers collègues, c'est moi qui vous remercie pour l'introduction, pour l'invitation et même pour avoir pensé à organiser ce colloque qui est vraiment fort intéressant. Quand j'ai vu l'appel à contribution et j'ai lu votre programme, votre projet de colloque, j'étais ravi de pouvoir participer. Alors, je commence par la question que je me suis posée, c'est-à-dire une question qu'on se pose assez d'ordinaire. Quels sont les systèmes qui mieux protègent les droits fondamentaux? Donc, c'est une question tout à fait banale pour ce qui est de l'efficacité des systèmes de justice constitutionnelle, mais bien sûr, c'est une question qu'on se pose en tenant compte d'une situation ordinaire. Et là, on s'est retrouvé à devoir faire face à une situation tout à fait exceptionnelle. Donc, ma question était la suivante, c'est-à-dire, peut-on nous poser cette question, la question traditionnelle, d'une façon différente? Ou encore mieux, peut-on arriver à des réponses différentes par rapport à aux réponses qui sont généralement données et qui sont des réponses qu'on pourrait synthétiser par un « ça dépend ». Il n'y a pas un système meilleur que l'autre. Il y a des systèmes qui sont plus performants que d'autres à certains niveaux, pour certains droits, pour certaines situations. Mais bon, en général, c'est difficile de donner une appréciation de qualité absolue. Mais peut-être avec la pandémie, la donne pourrait être changée. Donc, j'ai essayé mener une recherche sur ce point. Et je me suis aperçu que, en réalité, pour arriver à donner une réponse, ou à chercher à donner une réponse, il fallait aller un peu en arrière. Je commence en disant quelle est ma réponse, c'est-à-dire la réponse est que je n'ai pas de réponse. J'avais envoyé un résumé dans lequel je pensais de pouvoir donner une réponse en faveur de la nécessité d'une déconcentration du système de justice constitutionnelle. Mais bon, au fil des mois, j'ai vu que en réalité, les systèmes concentrés avaient repris leur élan, et donc je n'arriverai pas à donner un brevet de meilleure efficacité à un système plutôt qu'à l'autre. Mais bon, j'ai été obligé à retourner un peu en arrière du moment que la première des questions était celle de délimiter le champ de recherche. Alors là, j'ai pensé qu'il était peut-être bon de ne pas prendre en considération le modèle déconcentré, le modèle tout à fait déconcentré à l'américaine, pour ainsi dire. Pourquoi? Bon, parce que, à mon avis, là, c'est pas tellement un problème de système de justice constitutionnelle, mais plutôt de procédures spécifiques que l'on met en place pour garantir les droits en général et pour garantir les droits dans une situation d'urgence. J'ai éliminé de ma recherche ces systèmes et on verra à la fin que je suis arrivé à peu près au même point de départ, parce qu'un aspect important, c'est justement celui des procédures judiciaires ordinaires pour protéger les droits fondamentaux. Et alors, comme j'avais exclu les systèmes déconcentrés, je me suis concentré sur ce que je voulais appeler le modèle européen, en continuité avec une tradition comparatiste assez forte désormais. Mais en regardant de plus près les systèmes européens, et notamment avec l'œil bien fixé sur la pandémie, je me suis aperçu qu'en réalité, c'est très difficile de parler d'un modèle européen, car il y a une diversité entre les systèmes qui est une diversité profonde. Or, c'est vrai que quand on parle du système, du modèle européen, on fait généralement référence au modèle de Kelsen. Et cela est tout à fait correct, mais il faut quand même admettre que ce n'est pas seulement Kelsen qui a donné lieu qui a ouvert la voie à la justice constitutionnelle. C'est le modèle qui a primé sur les autres, qui était sans doute le plus performant, qui arrivait à permettre un développement en Europe d'une fonction, celle de la justice constitutionnelle, qu'au XIXe siècle n'était présent qu'au-delà de l'Atlantique. Mais il y a d'autres contributions à prendre en considération, et ce n'est pas un intérêt purement théorique, parce que, en réalité, je vois dans certains systèmes une empreinte assez forte de traditions différentes, d'idées différentes de celles de Kelsen. Par exemple, un aspect très important, il me semble, celui des théories de Heyning, et notamment le développement d'un organe capable de faire l'arbitre entre le pouvoir central et les pouvoirs périphériques. Or, je parle de l'Italie, bien évidemment, mais je suis connecté avec l'Université belge, donc c'est évident que dans la naissance de la justice constitutionnelle en Belgique, cet aspect des rapports entre le centre et la périphérie, c'est un aspect absolument essentiel. Puis, bien sûr, on s'est évolué, on a étendu les compétences, mais le début est celui-ci, à mon avis. Un autre rapport est celui de CIS. Car si on regarde l'évolution du système de justice constitutionnelle au cours de la Ve République, on s'aperçoit qu'au tout début, de l'avis du Conseil constitutionnel, il y avait encore des aspects très fortement ancrés dans la tradition constitutionnelle française et qui remontaient d'un côté à Rousseau et de l'autre à Sieyès. À Rousseau remontait l'idée de la volonté générale, l'article 6 de la Déclaration des droits de l'homme et du citoyen, et ce qui comportait au niveau de la protection de la loi. Mais à Sieyès revenait l'idée du jury constitutionnel, qui n'était autre qu'un organe qui n'était pas juridictionnel, un organe politique, et donc un organe qui permettait d'éviter le gouvernement des juges, qui rendait le jury constitutionnel et le Conseil constitutionnel compatible avec l'idée que les juges ne doivent pas s'immiscer dans l'activité politique, la loi de 1790. Et surtout, il y avait l'aspect que le contrôle de la loi était un contrôle nécessairement a priori. Ce qui était aussi l'idée de Sieyès, car c'était le seul moyen par lequel introduire un contrôle de la loi sans aller à l'encontre de l'idée que la loi est l'expression de la volonté générale. Donc, voilà deux exemples de systèmes qui naissent sur des fondements qui ne sont pas tout à fait reliés à Kelsen et qui, à la suite d'une évolution plus ou moins longue, plus ou moins importante, arrivent à jouer, à être insérés dans les systèmes kelséniens. Mais là aussi, il faut bien distinguer parce que quand on parle de système kelsénien, en réalité, on parle de choses qui peuvent être assez différentes. Si on fait une comparaison entre le système italien et le système allemand, donc deux systèmes qui sont nés à peu près, bien sûr dans les mêmes années, mais presque dans les mêmes mois, on s'aperçoit que la philosophie des deux systèmes est très différente. Tous les deux cherchent à compléter l'idée de Kelsen en mettant en place un système qui puisse offrir une garantie effective aux droits fondamentaux qui avaient été méconnus de manière généralisée pendant la dictature, etc. Mais en Italie, le système de justice constitutionnelle est né, comment dirais-je, pour combler un vide. L'idée qui fonde le système de justice constitutionnelle italien est celui de combler un vide. Qu'est-ce que je veux dire? L'état de droit en Italie, hormis la parenthèse de la dictature, était un état de droit qui fonctionnait. Il y avait les juges administratifs et judiciaires qui contrôlaient les règlements contraires à la loi, etc. Il y avait un vide au niveau des rapports entre la loi et la Constitution. Donc, quand on a introduit la Cour constitutionnelle, on a pensé à introduire un organe qui puisse combler le vide qui existait au niveau de l'état de droit. Et voilà que la Cour constitutionnelle italienne n'a que très peu de compétences. Si vous regardez la liste des compétences de la Cour italienne, vous serez assez déçu parce que 4 ou 5 compétences au maximum sont celles que la Cour constitutionnelle a. Et pourquoi? Pour cause, parce que la Cour constitutionnelle était censée arriver là où les juges n'arrivaient pas, ne pouvaient pas arriver, et notamment contrôler la loi. Ce n'est pas par hasard qu'en Italie, la Cour constitutionnelle est généralement définie dans la presse, mais aussi dans la doctrine, le juge de la loi, le juge des lois. Il y a même des livres qui définissent la Cour constitutionnelle, dont l'intitulé est le juge de la loi. En Allemagne, la chose est quelque peu différente. C'est-à-dire, le tribunal constitutionnel fédéral n'a pas été créé pour contrôler la loi. Le tribunal a été créé pour faire en sorte d'avoir un garant de la Constitution ou de la loi fondamentale plutôt, qui puisse intervenir à n'importe quasiment sur n'importe quelle affaire qui concerne la loi fondamentale. Et alors là, l'éventail des compétences du tribunal constitutionnel sont évidemment très... l'éventail est très riche. Et surtout, on a introduit une compétence qui est absolument révélatrice, c'est-à-dire le recours direct individuel, qui est un recours direct qui vise généralement les décisions de justice. Si on regarde les recours directs, la plupart, 90%, même plus, sont des recours directs contre les décisions de justice. Ça veut dire quoi? Ça veut dire qu'on a l'idée que le tribunal constitutionnel doit avoir une sorte de, pas de dire monopole, c'est sans doute excessif, mais doit concentrer en lui toute la fonction de garantie de la Constitution et donc de garantie aussi des droits fondamentaux. La Cour constitutionnelle italienne n'a pas cette fonction. La Cour constitutionnelle protège les droits fondamentaux qui sont méconnus par la loi. Or, en faisant cette distinction entre Italie et Allemagne, j'ai pensé qu'on pouvait introduire une distinction plus générale au sein du modèle européen, justement entre les systèmes de justice constitutionnelle qui visent à concentrer dans un organe la protection des droits fondamentaux, de la Constitution et donc des droits fondamentaux, et les systèmes dans lesquels le système de justice constitutionnelle est le résultat d'une coopération, d'une collaboration, d'une pluralité de sujets, d'organes qui interviennent, la Cour constitutionnelle ou la juridiction constitutionnelle générale qui protège les droits fondamentaux méconnus par la loi et les autres organes qui arrivent à intégrer la protection dérivant en censurant les méconnaissances de la part d'autres actes. Et c'est pour ça que quand on arrive à la Cour constitutionnelle italienne ou à d'autres cours constitutionnelles qui sont conçus comme pour combler le vide dont je parlais, l'attention est pointée sur l'acte qu'on censure. Parce que c'est là que les conditions de recevabilité sont fixées par l'objet, c'est-à-dire l'acte. Et la protection des droits, la censure concernant la méconnaissance du droit est la conséquence de l'acte qui est attaqué. S'il y a une méconnaissance d'un droit, la Cour constitutionnelle doit d'abord vérifier s'il y a effectivement la loi qui méconnaît le droit. Alors que dans les autres systèmes, et notamment ceux qui ont un recours direct, il suffit qu'on s'interroge sur la méconnaissance d'un droit fondamental. Et l'objet, bien sûr, est important, mais ce n'est pas le centre de l'affaire. Ce n'est pas le premier et décisif passage de tout à fait. Alors, cette distinction est assez intéressante à l'ordinaire, mais devient centrale quand on parle de la pandémie. Pourquoi? Parce que, en général, à l'ordinaire, on a encore les vestiges de l'idée que la loi protège. Surtout, sur le continent européen, on a cette idée que la loi protège. Si vous lisez la Constitution italienne, qui n'est pas une constitution jacobine, pas du tout, mais vous trouvez un nombre impressionnant de réserves de loi. Et les réserves de loi sont notamment concentrées sur les droits fondamentaux. Pourquoi? Parce que les droits fondamentaux sont au nombre des décisions les plus importantes. Et les décisions les plus importantes doivent être adoptées par le législateur, parce que l'adoption par le législateur est en soi une garantie. Donc, si la loi doit généralement intervient quand il s'agit de droits fondamentaux, à l'évidence, les deux catégories de systèmes ne fonctionnent pas de manière terriblement différente, parce qu'il s'agira de pointer l'attention d'abord sur l'acte ou d'abord sur la méconnaissance, sur le droit méconnu, mais en général, les deux cours, la cour qui comble le vide, la cour italienne et le tribunal allemand, arriveront quand même à juger sur la méconnaissance du droit fondamental. Or, dans le cas de la pandémie, on l'a très bien entendu dans l'intervention qui m'a précédé. Là, on a eu un problème parce que l'urgence a fait en sorte que ce n'a pas été généralement la loi qui a limité les droits fondamentaux. Et alors là, a priori, on aurait pensé les systèmes qui se focalisent sur les droits fondamentaux, les systèmes allemands, continuent à fonctionner comme ils fonctionnent généralement. Alors que les systèmes qui sont fondés sur l'idée du juge constitutionnel comme juge de la loi sont des systèmes dans lesquels le juge constitutionnel devient défaillant parce qu'il n'a plus d'objet sur lequel s'appuyer pour contrôler les lois, les méconnaissances des droits fondamentaux. Là, c'était l'hypothèse dont je suis parti, je suis arrivé après la recherche générale. Et bon, alors j'ai pris 3 systèmes pour chaque catégorie. Les 3 systèmes sont d'un côté Allemagne, Autriche et Espagne, de l'autre Italie, Belgique et France. C'est vrai que la Belgique est au recours direct, mais en étant le système, le recours direct, en ayant l'objet législatif comme objet principal, je pensais de pouvoir mettre ensemble la Belgique, France et l'Italie. Quels ont été les résultats? J'ai vu que j'ai été trop long, j'ai fini ça et je m'en excuse. Alors, les résultats ont été quelque peu surprenants parce que si on regarde l'Allemagne, on s'aperçoit qu'effectivement, le tribunal constitutionnel a pu avoir un rôle absolument clé dès le début. Parce que le nombre de décisions que le tribunal a rendues à partir du mois d'avril 2020 est un nombre considérable et il a abordé un certain nombre de questions très, très importantes, très difficiles, très discutées. En Autriche, il s'est passé à peu près la même chose avec un décalage, c'est-à-dire on a dû attendre la mi-juillet. Donc, on a dû attendre la fin du premier confinement, mais après, le tribunal constitutionnel, la Cour constitutionnelle autrichienne a fonctionné effectivement de manière à assurer une garantie des droits et donc une orientation même pour les décisions politiques. Alors qu'en Espagne, on s'est aperçu que le tribunal constitutionnel a dit très peu de choses. Or, je parle un mois ou 2 mois après la célèbre décision sur l'état d'urgence, mais et donc j'ai quelques embarras parce que désormais le tribunal constitutionnel s'est prononcé et a donné un avis fort sur l'état d'urgence. Mais il faut quand même constater que auparavant, il n'avait quasiment rien dit sur les droits fondamentaux au cours de la pandémie. Donc, on a dû attendre presque un an et demi. C'est quand même pas mal. Au niveau d'efficacité. En se tournant vers les autres systèmes, là, effectivement, les réponses sont aussi très nuancées parce que en Italie, la Cour constitutionnelle a commencé à donner à rendre des décisions importantes au mois de mars, mais de mars 2021. Donc, la Cour constitutionnelle a été complètement exclue du débat pendant un an. En Belgique aussi, la Cour constitutionnelle a eu un rôle assez marginal. Et c'est en effet la jurisprudence ordinaire, la jurisprudence judiciaire administrative qui a eu un rôle beaucoup plus important. En France aussi, le Conseil d'État et la Cour de cassation, à certaines mesures, ont eu un rôle important. Mais en France aussi, le Conseil constitutionnel a joué un rôle significatif. Et cela, pourquoi? Parce qu'en France, on a légiféré plus qu'ailleurs. Or, le résultat de ma recherche est à peu près celui-ci. La quantité, l'efficacité des systèmes ne peut pas se mesurer simplement par les décisions des juridictions constitutionnelles. Parce que quand on parle des juges de la loi, des juges qui comblent le vide, etc., on ne peut pas porter une appréciation de la justice, du système de justice constitutionnelle sans tenir compte des juridictions judiciaires et administratives. Et là, par exemple, la comparaison entre France et Italie porte à considérer que les droits sont protégés, surtout lorsqu'on a une procédure qui offre effectivement une protection urgente. Les référés en France ont eu un effet très important pour protéger les droits, alors qu'en Italie, les procédures d'urgence ont été très défaillantes et très décevantes. Donc, c'est un peu une invitation à regarder les systèmes de justice constitutionnelle d'une manière un peu plus générale, en ne pas se concentrant sur le juge de la loi, mais en allant au-delà et en cherchant dans la coordination des différents juges la manière la plus efficace de mesurer le degré et l'attitude du système à protéger les droits fondamentaux. Je vous remercie de votre attention. Je m'excuse pour la longueur de mon intervention.
Merci, professeur Passaglia. Vous apportez des éléments complémentaires à l'analyse que nous menons ce matin dans le cadre de ce panel. La plupart des orateurs ont opté pour une optique plutôt européenne ou internationale des droits fondamentaux, et ça s'explique certainement par la dimension internationale que nous avons voulu donner à ce colloque, et vous apportez des réflexions qui sont davantage focalisées sur le fonctionnement de la justice constitutionnelle à l'intérieur des ordres juridiques nationaux. Et puis, vous invitez à prolonger la réflexion en lisant votre rapport écrit que j'ai eu l'avantage de lire en primeur. Vous posez des questions intéressantes à la fin de votre article qui lance des pistes pour la réflexion future sur la justice constitutionnelle. The sixth member of this Monday morning panel is our Belgian colleague, Catherine van der Heyning. Just one second, I have a small problem with my computer. Sorry for this. So, Catherine van der Heyning is associate professor at the University of Antwerp, and she's also a public prosecutor. She combines the position of professor of European fundamental rights law at the University with judicial practice in criminal law. In addition, she is a member of the advisory committee to the UN Human Rights Council. Together with Professor Patricia Poppelier, she co-authored several op-eds on the protection of the rule of law and fundamental rights during the pandemic. I especially remember the one you published both in French and Dutch in last November, inviting the Belgian Parliament to wake up and to take its responsibilities. It has been signed by several members of the scientific committee of this symposium. Like Lisbeth Todd's 2 hours ago, you will discuss one of the key concepts of human rights law. In your case, it's the notion of margin of appreciation. Thank you, Catherine, for your presentation. You have 20 minutes.
Thank you very much for giving me the word. And thank you also to the organization for organizing this excellent conference, but also for inviting me. I'm not sure whether my slides are already shared.
Not
so otherwise
yet.
I'll share them now.
We don't see them.
Okay, then I'll share them now. Share.
Yes, it's coming. Thank you.
Okay.
Perfect.
So thank you very much. Given also the fact that the time is already is not on our side, so to speak, and I really hope that there's still a lot of time for debate. I'm really going to focus during my presentation on the core of what I want to discuss with you today. And the summary or my hypothesis is that we should rethink emergency. Even more, that probably we have failed during this crisis at doing what we do as legal scholars, as lawyers at our best, namely to put in nuance, and that probably during this crisis we haven't thought sufficiently nuanced about what an emergency entails. So my focus will not be, which was already discussed and very well by my colleague Dr. Tots on on legality. I will focus much more on the margin or a discretion that courts provide when balancing limitations of fundamental rights. I'm quite sure, just by means of introduction, but this is core knowledge that you all have, that of course human rights, except for the absolute rights, can be limited if there's a legal basis, which was already discussed during this seminar, for the specific aims provided in a conventional text, and only insofar as proportionate. And the proportionality test means that you need to balance. You will need to balance limitations to human rights on the one hand, and on the other hand, other rights or public interests, such as, of course, and that is crucial here, the protection of public health and life. And for this proportionality test, several courts will give some discretion to authorities. When we talk about European Court of Human Rights, that is well known as a margin of appreciation, and often it's also our focus because it's so well developed by the court and theorized both by the court and academia, that it is really one of the crucial tools to assess what such a maneuvering space for authorities means. But in national courts, or for example, European Court of Justice, it is sometimes labeled as a margin of discretion. Some national courts actually call it maneuvering space, but it all comes down to the same, namely that for certain reasons, the balancing and the proportionality test as to the content should in general be left to the authorities, and that the court will assess deeper or lesser scrutiny as to the outcome. And it sometimes also means if there's a very wide margin of appreciation that the control by the courts is actually limited to the test of arbitrariness, which is of course a very low threshold to establish. There are several reasons to provide for such a margin, or the theory or the principle why a margin is provided to authorities. There are several reasons. For supranational courts, it mostly comes down to subsidiarity, namely that that they are supranational courts, that national courts and national authorities are better placed often to balance these interests and rights, and that because they have a direct contact with situation, population, and can better have more the sensitivities, can better assess the sensitivities in a specific context. As to national courts and also supranational courts, another element to provide for a margin or discretion to authorities is the one of democratic legitimacy. Majoritarianism has not the same impact at continental Europe as it has in the United States, but still, of course, the authorities have a higher democratic legitimacy than courts, and therefore courts will in general decide with certain restraint as to the outcome of balancing of rights and interests. And a final reason why often certain discretion or margin is provided to authorities when balancing rights and interests is technicality and expertise. In particular, where the balancing and rights is in certain fields with a high level of technicality, where scientific results and scientific research is essential to understand the issue, and where it's really a very nuanced and complex decision-making process, you will also see that often courts as well, we as courts, we as judges, of course, do not have the same technical or scientific background. So a certain margin should be provided to authorities when they rely on expertise to come to a certain conclusion. Now, the question, of course, is what this means to the COVID pandemic. Because, and I think every of our contributions can start with the sentence that, of course, the COVID pandemic was an unprecedented challenge to our current constitutional and democratic society. And courts confronted with the COVID measures when they had to decide on whether COVID measures were a proportionate limitation of human rights or constitutional rights, in general have decided with quite some restraint, and often not raising above that threshold of arbitrariness. And looking at arbitrariness and whether there's a legal remedy, and basically then leaving the balancing to authorities. And given the unparalleled challenge to public health, the uncertainty on the development of the virus, the lack of knowledge, the speed as well with which we were confronted with this crisis, I think that it is very clear that at that point in time, courts were well positioned to decide on a wide margin or a wide discretion to authorities, and that a certain flexibility and to react was required. And that you will see that as well in other emergencies, that the courts will react with more restraint to the balancing exercise. And so when you talk about limiting human rights in times of crisis, you can see two potential routes taken, and that is the case as well in this crisis. Either authorities will rely on explicit emergency clauses, either in their own constitution or national law, or on the other hand, of course, Article 15, which was already well discussed by a previous speaker in the convention. But actually more often, which was also already developed by a previous speaker, is that often the authorities did not rely on that explicit clause, provided emergency clause in Article 15, or even did not have always triggered the national constitutional clauses of emergency, but relied on the general theory on limiting fundamental rights, namely that fundamental rights can be limited, in particular in times of crisis, where there is a threat to public life and public health, and that warrants a very wide discretion or margin. And you actually see that in several of the briefs submitted to constitutional courts in Europe, or in or other highest courts in Europe, that authorities will plead themselves that they should be provided with a very wide margin. Why? Because a swift reaction was needed, because there's enormous impact on the budget, but also the available resources, that in such a crisis that a government or authority should be agile and flexible, and that courts would go along with this train of reason, and that the only limitation, as mentioned, would be arbitrariness. What is the point with emergency? Of course, emergency is not just a reason put forward to limit fundamental rights in an ongoing policy debate, but is an exceptional situation where, as we see, courts are more lenient, and therefore also it is very important to study and to delineate what an emergency is because of the major impacts, both in democratic, well-established, rule of law, human rights protecting countries, as in non-democratic, non-rule of law countries. In this crisis, often the same measures have been applied, such as strict lockdowns or high level of surveillance, restriction of freedom of movement, etc. The difference between the two systems must be the judicial review in order to prevent, one, that these restrictions would become the new normal, and you would undermine democracy and rule of law and human rights, and second, to prevent arbitrariness. If we go to the definition of what an emergency is, there are several legal definitions, both in national constitutional law, also in academia. There's a famous definition as well from the International Jurist Commission, but this one is very close to that one. It is the definition as to what constitutes an emergency in Article 15 of the Convention. And it was defined by the European Court in a famous lawless case, I may say, as a situation that is exceptional, of imminent danger, and that was in other cases mentioned as imminent or actual danger, affecting the general public and constituting a threat to the organized life of the community. And if you would apply that to COVID, and once again, I need to repeat what has been said before, I think we can all agree that we would come to that level of what constitutes an emergency, that this was exceptional, unprecedented, and that this really tested our society to the extremes, and that there was an actual danger to life, integrity, public health, that this affected the general public, I would even dare to say the globe, and that this was a clear threat to organized life. And so there is no discussion that there was an emergency. There is no discussion that even today there is still at global level this emergency. And the court has always stepped away from deciding on a specific period to define an emergency in a specific period. As such, an emergency can last many years. That was, for example, the case with the terrorist threats, where it was mentioned that this emergency, also 10 years after 9/11, was still an actual and imminent threat, and was still a crisis and still an emergency that could justify a wide margin for countries to decide on. And so an emergency is not a specific defined moment, but can be a period, has a certain duration. And this is something that you will see coming back in also the case law of national courts. And I have decided now to take a case study which I will develop from a national court, the Belgian Council of State, to really, to make more practical what the theory I'm putting forward. And this applies to what an emergency is. You can clearly read that into the case law of the Belgian Council of State. You will see that this is a quote really from the beginning of the crisis in Belgium, where the court stated that indeed this was an exceptional and very serious health crisis. And so this constitutes an emergency. And that because there's an emergency, there is a very wide discretion for the authorities to strike a balance between the distinct and often conflicting interests. So emergency and a wide margin go hand in hand. And I think this is what we need to rethink. It is what constitutes an emergency. Because the definition provided of what is an emergency is very static. An emergency is defined on certain parameters that in March last year, but also today, could still be applicable. However, we are in a completely different situation. We have more knowledge about the crisis. We have new tools, being vaccinations, to tackle the crisis. We are much advanced in what we know, what works, what doesn't work. And we also had the possibility to debate, to research, and also to have certain groups to participate also in discussion. So we're still in the legal same situation as to what constitutes an emergency, but our reality is completely different. Also, the degree of a crisis, the spread of a crisis, the impact of a crisis can be very different from, for example, terrorism to the COVID crisis or to our future climate change crisis. And so by adopting this static definition of an emergency, which warrants then a wide margin of appreciation, we might actually be undermining the protection of human rights. So there is a lot of research actually on what constitutes an emergency in social fields of research. And so I did research in other fields of social sciences, and in particular on emergency management. And there's a very established theory of think, which was further developed by other scholars, that a crisis is not an emergency, is never a static given. It exists, and this is a common accepted theory, that it exists of 5 phases. That it starts with acknowledging that there might be a threat and with potential prevention. Afterwards, the moment that you see that prevention will not be sufficient, that you will go into mitigation. We need to prepare for this crisis to come. The crisis is coming. How should we deal with this crisis? And then from that mitigation phase where we have some ideas, we're going to execute these ideas in preparedness. And this preparedness, for example, was that we would ask hospitals to have intensive care units prepared, to have more doctors, to maybe ask doctors not to go on holiday, to buy masks, etc. Then the crisis is really upon us and we need to respond. And this is probably the most crucial or the most heated part of a crisis, where we had the lockdowns and the very restrictions. And afterwards, you have recovery, which is probably the exit strategy if you talk about COVID, where the intense period of crisis is past, and where we try to make sense of what happens. And what we learned from COVID is really that it is not a line, but it is a circle. Because what we had was several waves of a COVID spikes, and each time we went again into that mitigation, preparation, preparedness, application, recovery phase. And every time, of course, during that period, we had more knowledge, but we also had more time, because when the first wave had passed, we had time to rethink the measures that were applied, to have democratic debate about which limitations we want and we don't want, to have an inclusive assessment of measures, and to prepare for the coming new wave, which we knew already was upon us. And so not only European countries, But the globe went through several of these waves that should have, and every spike is an emergency, is a heated moment of emergency, but actually the whole period of waves of emergency, as you can see, is not static. And so as every phase of this crisis, we gained additional expertise, time to reassess, and a possibility to prepare. That also means that the margin provided by courts to authorities should also tighten wave after wave, because of course there is no unexpected, unprecedented challenge anymore. There's more knowledge. And so the authorities should also, you can also request from authorities to have a more detailed, more specific, more tailor-made approach, limiting the impact on human rights. That does not mean that necessarily when we are reviewing, or when courts are reviewing the decisions made by the authorities, that as to the balancing, that they should tighten the margin, in the sense that a government or an authority should still be agile and flexible, which we have seen also that during a second or third wave, you can have the same kind of emergency where direct action is needed, and where often you cannot ask all the minority groups or interest groups to participate. But what should tighten is the margin as to how decisions are made, how decisions are prepared, and what you have done in the intermediate period as to response, preparedness, research, etc. And so that there should be a certain procedural rationality, and that if a state has not taken precautions, has not asked for expertise, has not had this preparedness, then the margins should be more narrow, and a court should apply a stricter scrutiny than where actually an authority has been diligent and has this preparedness and mitigation. In that case, there should be a wider margin of appreciation for the authorities. And that was actually something that you've seen certain courts doing. And I'm going to go back to my example of the Council of State in Belgium. When the pandemic hit Belgium, all the places of worship were closed and afterwards limited to only very few people that could come together and associate in these houses of worship. And to be able to worship is a crucial element, of course, to the freedom of religion, and is protected in the Belgian constitution, and of course a human right. And the Council of State has repeated several times how crucial this worshipping is as to the freedom of religion, and how crucial that it is. But however, that given the pandemic, given the impact, given the lack of knowledge as to the spread, that this was at the beginning a proportionate limitation, and that the authorities should be provided a very wide margin. And so at first the Council of State accepted this very wide margin. However, along the way, there were certain exit measures and exit strategies where you could see that in certain places people could gather again, for example, the shops. And of course, the House of Worship said, but we should be able to gather again as well in our houses of worship with more people, because if it's possible in a shop, why not in a church, a mosque, a synagogue? And the authorities made the comparison often with culture or sports, where there was also the same limitation. However, the court decided that the first principle, this wide discretion in choice of measures, should tighten when more knowledge was provided and when also the nature of the emergency and the crisis changed. And this was applied in a judgment of 8th of December on Jewish marriages. And actually the attendance was limited to 4 persons. However, for a Jewish marriage, you actually need 10 persons, 10 men to be present as a witness for such a marriage to be legitimate, so to speak from the Jewish belief. So that was a major problem for Jewish marriages. And so some went to the Council of State to enable these marriages with more people. And the Council of State decided that indeed the epidemiological situation was still worrying. So the Council of State accepted that there was still an emergency, that there was still a crisis, that the duration of the crisis was still ongoing. However, they noted that there were other relaxations of measures, certain exit strategy measures, that there was still a blanket ban for more people to gather in houses of worship, that it was not tailor-made, not specific, and that there was no in-depth research as to alternatives to enable meaningful worshiping in those places and gathering of people in those places. And for example, that the specific interests of the Jewish community were not taken into account. And so the Council of State came to the conclusion that there was reason to believe that a thorough investigation of specific circumstances in this case would have enabled for worshippers to come together and exercise their freedom of religion and worship without a danger of a significant increase in the rise of infections. And I think this is a very crucial judgment. And there are several others I'm developing in the paper on, for example, terrorism as another challenge, or the potential in the future of climate change, where I do believe that we need to rethink what an emergency is as a non-static concept for the limitation of fundamental rights. Thank you very much for your attention.
Thank you, Katrien van der Heyning, for your contribution, which builds bridges between the different contributions of this panel, from the Article 15 of the European Convention to the fascinating legal notion of threat or risk. You bring a central piece for our coming debate. But before opening the general discussion, I turn myself to Amy Wedderburn, who will present the last intervention of this morning. She will present a collective work led with Paul de Hert and Giulia Zaminiani Barbosa. Amy Wedderburn is a scientific collaborator, FNRS at the Université Libre de Bruxelles. She is Doctor of Law from VUB and Tilburg. Her main research areas are human trafficking, migration, and fundamental rights. She coordinated several European-funded research projects and led the Belgian National Research for the Multidisciplinary Research Network of the European Union Agency of Fundamental Rights, FRA-net. And this is linked to the topic of today. The title of her presentation is the following one: An assessment of the FRA Fundamental Rights Monitoring Mechanism, case study on COVID-19 emergency measures adopted in Belgium. The floor is yours.
Thank you very much. And thank you for the invitation to present this paper today. The focus is very much on the importance of independent and reliable human rights monitoring, which is pivotal to ensuring effective protection of individual rights. And this is even more so the case in times of crisis, and specifically in response to COVID-19. And especially if we consider the unprecedented interferences that we've seen with personal freedoms imposed by the sanitary measures enacted by governments, and the safety concerns of an expedited vaccine rollout. And over the course of the last 18 months, some of the concerns that have been raised about the interference with fundamental rights have often been questioned before the courts and in the form of protests, as from the judicial scrutiny we've just heard from previous speakers. So on the 30th of January 2020, the Director General of the World Health Organization declared COVID-19 to be a public health emergency of international concern. And in February, we saw the emergence of COVID-19 cases in EU member states. And there were not only concerns about the protection of the right to health, but also the implications of sweeping restrictions on fundamental rights, including, for example, the freedom of movement, another topic we've discussed today. And in response to the introduction of these emergency measures, the European Union Agency of Fundamental Rights, the FRA, have between March 2020 and May 2021 monitored the fundamental rights implications of COVID-19 in the EU. To date, there have been seven regional bulletins that have been published, accompanied by data from the different EU member states, the country data as well, on the human rights implications of the pandemic. And the national perspective was provided by the national contractors of the agency's FRA-net research network. And in Belgium, the national contractor is currently the Fundamental Rights Research Centre at the VUB. I'll first discuss the emergence of the role of the state in response to COVID-19 with some examples from Belgium, and then move on to looking at the importance of fundamental rights protection in times of crisis, with obviously the focus on COVID-19. And finally, I'll then turn to the importance of human rights monitoring and impact assessment with a focus on the role of the FRA and a reflection on the added value and challenges of such human rights monitoring. So overall, the global state-centric response to COVID-19 prioritized the protection of public health and economic interests, leading to the imposition of lockdown measures and other restrictions to fundamental rights and freedoms. The state's capacity to design and implement effective policies in response to the COVID pandemic could first and foremost be examined according to the numbers of cases, the number of hospitalizations, infection rates, the number of patients recovered, and indeed the number of COVID-related deaths. These measures do, however, depend on a number of variables, such as the share of the elderly population, the health system, the capacity in terms of resources, and the different methodologies for reporting mortality rates. There's also evidence of other factors that could impact the effectiveness of any policy responses, such as the level of democracy and the type of political regime. So given the difficulty in actually being able to compare mortality rates, for example, and the lack of a unified reporting system, it's important that we also examine the effectiveness of these public health policies through the reflection on their socio-economic impact and, of course, the respect for fundamental rights. We should also consider those for whom many of these measures were actually inadequate. For instance, social distancing wasn't possible for homeless persons, or for people living in poverty in crowded conditions, prisoners, and people in long-term care facilities. And similarly, many undocumented migrants have not been able to access vaccines. In Belgium, we've seen multiple ministerial and royal decrees that have been enacted since March 2020 to determine the measures that were to be followed to contain the spread of the COVID virus. And there was a wide range of measures, including the closure of businesses, restaurants, hotels, a cessation of sport activities, of religious activities, as we've just heard. And there was serious restrictions on private and family life and travel. While most of the restrictions in Belgium were introduced at federal level, the extent and implementation of them did vary across the different regions in relation to the freedom of movement, access to education, the restrictions that were imposed on elderly persons, access to support services for persons with disabilities, and the different measures when it came to assisting domestic violence victims. And equally, the legality of the emergency measures and the impact of these sanitary constraints have also, on certain groups, have led to multiple judicial complaints before the Council of State. Again, as we've heard, an example in the previous presentation, and another example is in October 2020, the Council of State actually rejected complaints contesting the decision to close HoReCa facilities and to create a federal curfew. There was one decision by the council to suspend the measure that had been imposed by the Brussels mayor that prohibited prostitution for an indefinite period due to COVID, as it was deemed that such a measure didn't fall within the competency of local authorities. And there have also been judicial cases, for example, that have questioned the measures that affect asylum seekers, which have succeeded before the courts. An example here is in October 2020, the Tribunal de Première Instance francophone de Bruxelles ruled that the online registration system that was put in place for requesting asylum at the beginning of the crisis was actually illegal, as it didn't allow immediate access to material assistance. Instead, the asylum seekers had to wait until they actually had their appointment, which could have been weeks later. When it comes to the exit strategy, with the evolution of the pandemic and the development of the vaccines, we also had to take into account with the reporting on the situations as it changed. And so in 2021, the focus of the reports on Belgium were really looking at the vaccination campaign and any certificates for vaccination or negative testing or sanitary passes. In Belgium, the vaccination campaign, we also wanted to look at how effective it was in terms of accessing vaccinations, and in particular, how in practice vulnerable groups, such as persons with disabilities or homeless persons, undocumented migrants, would actually be able to access the vaccinations, get information about the vaccinations, and be able to express their preference of whether or not they wanted to be vaccinated. For certain vulnerable groups who are not likely to have their contact information in the National Register, vaccination was often done through civil society actors that gave them assistance. But there was concern from these actors that actually this approach was not necessarily, could lead to some problems if the vaccines weren't kept in the correct conditions when they were being used for mobile units, for example. In other European member states, we've seen debates about the implementation of sanitary passes, and the potential introduction of these passes did raise concerns. And for example, UNIA, the equality body, raised concerns about the possibility of creating unacceptable differences between the vaccinated and unvaccinated members of society. But in the end, the government assured that the use of sanitary passes was restricted only to high-risk events and wasn't going to become widespread in the use. I'm going to briefly go through this because we've heard this already today from all the previous participants and contributors. But essentially, we know that states are permitted to implement restrictions in where there is a public threat or a public emergency, and that this has to be prescribed in law, necessary in a democratic society, pursue a legitimate aim, and be proportionate. And again, we've also mentioned today this idea of temporariness and the fact that we need to be sure that these measures are reviewed and do not become permanent. A brief example here is a concern from the UK, where the Police Crime Sentencing in Courts Bill actually appears to be prolonging and implementing measures that initially were used purely for COVID purposes, but actually they're going to turn out to be more long-term, such as measures that curtail freedom of assembly and requirements for court users to appear remotely via video link. So in this regard, fundamental rights monitoring is a tool to mitigate the risk of potential violations and ensure the legal basis of any restrictions. And again, I'm going to go through this quite briefly because we've discussed this already, but we've seen an emphasis on the economic and public health priorities in terms of the lockdown and exit strategies that we've seen. But there has been a failure to safeguard human dignity and to protect the weakest and the most vulnerable, both in the short and long term, against the negative effects of the pandemic. And the marginalization of a response premised on social governance fails to pay attention to human dignity, respect for rights, and for people in most need of support. And for this reason, a normative response grounded in fundamental rights must be integrated and not seen as a competing policy objective. To give an example, in Belgium, where this has been contested, in February 2021, the League of Human Rights referred a case to the Tribunal of First Instance of Brussels to challenge the legality of the management of the health crisis through the use of ministerial orders and the legal basis that this might, the impact of this legal basis in terms of limiting fundamental rights. The Court of First Instance actually upheld the arguments of the Belgian of the League of Human Rights initially, and ordered the Belgian state to take all appropriate measures to put an end to the situation of apparent illegality arising from the measures restricting fundamental rights and freedoms. And the Belgian state had 30 days to comply, with a potential penalty of a fine of 5,000 euros per day for every day of delay. However, in June 2021, the Brussels Court of Appeal overturned the decision and rejected the application of the League, finding that the measures prima facie did not appear to be manifestly illegal. However, since the Court of Appeal is not competent to review the constitutionality of laws, the matter has been referred to the Constitutional Court. What's interesting is that the Court of Appeal did express that the process had raised serious questions in terms of respect for fundamental rights as enshrined in the Constitution and the European Convention. So when it comes to human rights monitoring impact assessment, we can see that the legal action taken against Belgian authorities and the exceptional circumstances in which these restrictions are introduced illustrates the importance of objective, independent and external monitoring, which human rights monitoring is a tool which can be used to ensure respect for rule of law and legitimacy of the legislative measures implemented. They can also assess the impact of the measures on existing structural inequalities as well, where certain groups may require additional support and assistance to mitigate any disproportionate effect. And in the very early stages of the pandemic, the many emergency powers invoked by states on the dual basis of protection of public health and economic stability led to organizations and civil society raising the need for responses to COVID-19 to ensure respect for all fundamental rights. And the Fundamental Rights Agency also recognized this and implemented this bi-monthly reporting that we were required to do, where every 2 months we would collect data on the current situation. And the data would look the data was collected from public sources, but where information wasn't public, we also liaised with government representatives, human rights institutions, and civil society actors. The initial reporting really did focus on the measures that affected social life, education, work, and freedom of movement, and the particular impact that this would have on certain vulnerable groups. And this was even more so the case in later reporting, where there was a specific focus on, for example, Roma and travelers, and also the implications on the social rights of vulnerable groups when the second wave saw the protraction of the measures and restrictions. And in terms of the added value and the potential challenges that we've seen from this exercise, we need to first take into account the context of COVID-19 with the rapid spread that was initially surrounded also by a great amount of misinformation and speculation due to the lack of scientific knowledge about the virus and its transmission. And this resulted in a wide variety of sanitary measures where even amongst member states, you saw a distinction between the measures that were particularly restrictive, while other measures were introduced merely as recommendations and weren't necessarily enforced. And as we knew more about the pandemic, the shape and the duration of these measures also started to change. And we've seen, as we saw in the previous presentation as well, the impact of different waves of pandemic and the relaxation of measures and the reintroduction of measures, which did lead eventually to some mistrust in governments and certain people not taking the measures seriously. So with this background of skepticism and uncertainty in mind, The FRA's independent and unbiased human rights reporting does play an important role in providing a one-stop shop for stakeholders to identify the different measures applicable in EU member states and the associated human rights concerns that have been raised by multiple actors, including government authorities, civil society, and in the media. The fact that the bulletins were published on a bi-monthly basis ensured that the information was up to date and they were available in a timely manner, which made it possible for stakeholders to stay informed, adapt their policies to the most recent developments, and address any human rights concerns. The EU-wide bulletins were also, as I mentioned, they were always accompanied by the country data for each member state, which also meant that national stakeholders would have access to the domestic assessment and also have insight into the general trends across Europe. Despite the added value of this monitoring, and considering we are documenting a historical moment, it's important, nevertheless, to consider the extent to which these the process of monitoring human rights can actually strengthen the application and respect of human rights. And to this extent, we don't really know exactly the impact of this human rights monitoring yet. But what we do know is that there has been a lack of recognition by states to ensure that policy responses have a minimal impact on fundamental rights protection. And we have also seen a significant absence of human rights and advocates and experts at the table, which is especially where we've seen how the pandemic has actually been significantly led by the expert knowledge. The fact that we don't have human rights experts there actually demonstrates a lack of recognition of the COVID-19 crisis as a human rights crisis, and potentially shows a lack of confidence placed in having a human rights-based approach as a reliable means of building back better. This also raises the question, to what extent are the findings of these bulletins and country data considered? And in the future, will governments take them into account when designing and implementing post-COVID landscape, and taking into account the possibility of future cases of global emergencies? So to conclude, the reality of the pandemic has shown that social differences matter. And with the benefit of hindsight, one of the lessons learned from this pandemic should be that during emergency times, exceptional measures should be implemented, taking into account all of those affected, especially the most vulnerable populations. In this regard, human rights monitoring and the engagement with and participation of various stakeholders on human rights concerns can be an important tool to influence and shape policy in times of emergency. And above all, human rights monitoring can ensure that public health emergency measures are proportionate and necessary, and that there is no long-term implementation or blanket application. Thank you very much for your attention.